Hi, my name is Seth Andrews, and this is End Time.
It's like we're in hell or something. No, it's Hill Valley, although I can't imagine hell being much worse.
Good afternoon, everyone. My name is Nicholas Lamar Suter, and welcome to In Time. We just did breaking news, and we are going to get to tonight's or today's main story in just a minute, but we have a little more breaking. I had told you earlier during that breaking news that there had been a number of emails released apparently damning Donald Trump. One of them said that he was open to blackmail for what had happened at Mar-a-Lago and for what Epstein knew. This was Epstein himself saying, telling writer Wolf that he could blackmail Donald Trump if he won, with knowing everything that was going on. And then the second one was that Trump had spent time with another victim, and that we had heard, but we didn't have the source yet, that the victim was Virginia Giuffre. Now, I did have the source, actually, but I figured that really couldn't be the primary source, so I just said we don't have a source because it needed more investigation. I have since investigated, and yes, it is the primary source. So, without further ado, just oh, dear Lord. This is the email, and we're just going to have to address it, even though it's not the primary show. It's breaking. It's happening now. Jeffrey Epstein writing to Ghislaine Maxwell, his co-conspirator, the two of them running a child sex trafficking organization together. I want you to realize that the dog that hasn't barked is Trump, suggesting that Trump knows something and hasn't said anything. Victim, it's been redacted, spent hours at my house with him, has never once been mentioned. So it's someone that is a victim that has not named him, and nobody knows why. Or not nobody knows why, but he's not giving a why. He may or may not know. Police chief, etc. I'm 75% there, presumably 75% towards getting out from under this, I assume. I have been thinking about that, as Maxwell says Maxwell, so she clearly knows. So the question is, who's the victim now? We have the testimony of one victim who spent a good deal of time with him being raped in the Mar-a-Lago, at Mar-a-Lago. So the question is, who's this new victim? And we have a source that's telling us that the victim was, in fact, Virginia Giuffre. The source is the White House. The White House has come out and said that the person named as victim there is Virginia Giuffre. This, according to The Guardian. The White House is just blasted on The Guardian. The Guardian is saying the White House has come out and confirmed that the victim is Virginia Giuffre. Now, that's a big matzo ball. Why would the White House do that? I'll get to the thinking here, at least what I think the thinking is. Virginia Giuffre was repeatedly asked if Donald Trump ever sexually assaulted her. She repeatedly said no. repeatedly said no. In no sworn, that is public, no sworn statements, no affidavits, nothing, does she ever claim that Trump did anything. And in fact, a number of the other public ones of the more than 200 confirmed victims who have testified we have the deposit, it's sealed, but 200 this is not a non-thing. Most of them say, well, it wasn't this, or this person, and we believe they're lying, and we believe they're lying to protect themselves, because if they come out publicly and say these things, they will be destroyed. If they come out with others in either a court case, they'll still be destroyed, but it's less likely. Unless it's protected, which it can be, and it has been in some cases. If they come out as part of a congressional investigation, that's a different thing. And so when people say, why didn't they name names when they were standing up, the 10 women who stood before Congress, the reason is because they'd all be destroyed. They would be destroyed. You're talking very powerful men, and men with no power have destroyed women who've accused them. This isn't so Virginia Guffrey, has repeatedly denied that Donald Trump has done anything. So it appears that the strategy that the White House is doing is saying, yes, Trump was with a underage girl for hours, but it was Virginia Guffrey who has repeatedly exonerated him, so it's okay. That's their defense, and that's what they're saying publicly. So to bring this back up for a second, so the White House is saying that victim there that has been redacted is Virginia Giuffre. Now, first of all, this email imports that she is in fact a victim. And the person who redacted it and said victim, whoever redacted it, and it was somebody in a position to know, believes that this was a victim. So whether it was Virginia Guffrey or someone else, it's a victim. Epstein here is clearly thinking that whatever happened with those hours in the house is going to implicate somebody. That's his whole concern here. You don't bring this up in this set of circumstances unless you're concerned about it. And what the hell was Trump doing in Epstein's house with Virginia Giuffre for several hours? An underage girl that presumably was working for Trump at the time in a massage parlor and has accused Epstein of a whole bunch of absolutely horrible, terrible things. Coming out and confirming that that was Virginia Giuffre is about the dumbest thing I have ever seen. Holy smoke. And thank you, by the way, to the White House for confirming that the email is real. That implies that the other emails, including the ones saying that Trump should be blackmailed for what he knows, are also real. So the White House has just confirmed all of it. Thank you. Wow. I'm not a lawyer, but in general, if you see an email like that, it's I would assume the answer is I have no idea what you're talking. I've never heard or seen them saying, "Oh yeah, that's Virginia. This is all a setup," and you can tell because the victim is Virginia Giuffre, who's only accused Epstein of horrific crimes. That's all. Wow. Okay. That was and like I said, I saw that the White House was confirming it, and I was just like, okay, this has got to be wrong, and no. So with that, we can get to our main story for today, and remember, we will be Guffrey. Yeah, I keep pronouncing the name wrong. My brain and names. So let's I don't know. I want you guys to be able to see this. So, state of the judiciary. Donald Trump has been attacking every branch of the United States government. We have three branches, and I know most of you already know this, but not all of you are Americans, so which we're very proud of. This isn't actually, strictly speaking, a show for Americans. It's a news show for anyone interested in it. It is in English, but that's it. Three branches of government: the judicial, legislative, and executive. Donald J. Trump is head of the executive. Now, they're supposed to be roughly co-equal branches of government. Donald Trump has been coalescing the power of the executive in ways that have been profoundly disturbing and are reminiscent of Pinochet. Pick a dictator, but I go with Pinochet for any number of reasons. I'm pretty sure that the average non-American knows more about the American government than the average American. I am pretty sure you're right. I have the most intense arguments I've gotten into about what the founding fathers intended and so on and so forth. I've been usually with Canadians or Europeans of some kind. It's not with Americans. They're like, what? Which speaks a lot about, unfortunately, our education system and the education system of other countries. At any rate, the judiciary has gotten, I think, a bad rap recently for two reasons. One, Eileen Cannon, who was obviously biased and should have been removed. I don't know to this day why Jack Smith did not ask that she recuse herself after she was utterly spanked. Well, I mean, in a way that I've not seen ever by the appellate court. She got spanked again, unfortunately, after the fact, and just too late to do anything about it. And I don't know why he didn't ask for a recusal, but she is one of the best known members of the judiciary right now that's not of the Supreme Court for obvious reasons. And all of us, I think, felt very betrayed by how biased she was. And there have been a lot of former members of the judiciary and lawyers who come out and talked about it. And the appeals court was crystal clear about what they were seeing. Unfortunately, it's too late for all of that right now. It's not too late for Jack Smith to make it public, and hopefully Congress will give him a venue to do that. Having said all that, the Supreme Court obviously has been very pro-Trump, and it turns out has voted for him about 90% of the time, or voted on his side, sided with him, 90% of the time. But having said that, the lower courts, and this would be the circuit courts, district courts, all the federal judges have all voted against Trump and his agenda 94% of the time. And you don't hear a lot about that. We covered a lot of that in the beginning, especially with Abrego Garcia, where motion after motion to send him out. And then after he got sent, despite, in violation of a judge's motion, the defense requested that they be forced back. Boom, he was forced back. The Abrego Garcia doesn't count as one, it counts as 10. There was about 10 different motions at the time filed by either the prosecution or the defense, and the judge sided with the defense in basically all of them. And it's not hard to see why. Now, when you look at Boston has, and I'm proud of this, Boston has been cutting edge in terms of judges telling Trump that he has overstepped the bounds of what he can do. In some cases, it comes too late. Harvard had already capitulated some, at least, by the time the ruling came in saying that Trump was unable to make any of the demands that he had made to Harvard or any of the other universities. The rulings in favor of the law firms that he was blatantly trying to blackmail and or bribe have been spectacular and exactly what I think all of the time travelers and myself would have hoped for. And they're all well justified. They are documented. They say, this is why I'm ruling this way. The exception has been the Supreme Court. Now, how has it been an exception and why and how bad is it? It's not as bad as it sounds, but it may get there. So it's not as bad as it sounds because most of this has been on what is referred to as the shadow docket or the emergency docket. The official name is the oh dear Lord, I think I've forgotten it. I'll have to look it up. But it's a docket that does not require significant evidence to make a claim or to get a ruling. However, rulings on the, quote, shadow docket are limited in certain ways. They have to be temporary in nature. They are not required to have any opinion or be signed. A record number of dissent opinions to the shadow docket have been filed this year, and they don't need a dissent either. You don't need an opinion or a dissent. Just say, this is the way we're ruling. Well, temporary. How so? Isn't the removal of the SNAP benefits a permanent thing, at least so long as the government is closed? No. The reason is because this was an appeal of a restraining order, which was by definition temporary already. So a lower court ruled exactly as you and I would have wanted. Two of them, actually. Two lower courts at the same time, within hours of each other, told the Trump administration to immediately begin fully funding SNAP. He appealed that decision. He lost the appeal. He asked for a temporary restraining order that meant that the decision not go into effect until the appeal is heard. He lost that. So he then finally appealed to the shadow docket of the Supreme Court. What they did was they said, we are staying the decision. Now, stay does not mean ending it. It just means stopping it for now. There's a stay in the decision until it can actually be heard. Now, that kind of ruling is reasonably, it's not frequent, but it's done. And what it is sometimes there is a decision that is so important and so critical and has to be decided so quickly that it has to be really decided before the judges can have a chance to even look at it. So what the judges will do is they will allow a temporary order. And this temporary order is has to meet two requirements. First of all, that if they don't do the temporary order, somebody, one side or the other, will receive irreparable harm that cannot be corrected. And two, that particular side is more likely than not to win based on just looking at the basics of the evidence. Haven't gone through it, haven't tried the case, nothing. Just looking at it, yeah, this side's more likely to win. There have been so many TROs against the Trump administration based on that argument. So when Garcia was ordered back, and he was ordered to be held in this country until his deportation status could be determined, the judge was saying, look, we haven't had the trial yet as to whether or not you can deport the guy, but we're not going to let you deport him while we wait. So we are issuing a temporary restraining order against you deporting him, because we think, A, if you deport him, that will cause irreparable harm, which it would, and B, you're likely to lose. So there's a temporary restraining order We'll have the trial, and if you win, you can deport him. Then that temporary restraining order gets appealed to the Supreme Court. The Supreme Court then says, you can have your trial. Go ahead and have your trial. We're not interfering with the trial, but the restraining order is gone. You can deport him while you wait. That's mostly what they've been doing. They've been eliminating the TROs and all of the injunctions that have been preventing damage while these cases go through trial. These cases aren't being heard by the Supreme Court yet. They're not doing any of that. They are unwinding all the rails that prevent damage while the cases are being tried. So and because it's the shadow docket, they don't have to sign the opinion. You don't know who voted how, unless somebody puts in a dissent. It just comes down from the court. It causes another problem. We have a common law system in the United States. And what that really means is that our laws are based on precedent. How have we ruled in the past? That's why lawyers have all those books in the background, is because you have to know how the law has been interpreted in the past to know how to interpret it going forward. So it's very important when offering an opinion to explain very succinctly, and we are going to show an opinion today, a very important opinion in my view today. It's very important to go through how and why, what arguments worked, what arguments didn't work, and why, so that other people in the future have guidance going forward. The shadow docket doesn't do any of that. So what you have is an increasing number of judges growing very, very frustrated with the U.S. Supreme Court, which is operating apparently contravening common law and how we understand the law to work, but they're not justifying how or why. And in one case, a U.S. Supreme Court justice actually called out one of the Boston judges and said he's operating contrary to the Supreme Court and contrary to the way we want him to. And his reply was, listen, I'm sorry. I certainly didn't mean to. But could you point to where? Because I don't see it in the, and what they really meant was he wasn't following, he ruled against Trump when they had previously ruled for him, but they didn't give a reason. So he doesn't know what reason they used. He doesn't know if the reason is still valid. Maybe they ruled against him because it was Tuesday and now it's Wednesday, so we can rule for, the other way. He doesn't know. And it's very rare for the U.S. Supreme Court to do that. So there is now this dramatic tension between the Supreme Court of the United States, which has ruled with Trump more than 90% of the time, and the rest of the judiciary, which has ruled against him 94% of the time. 94% of the cases that Trump has been involved in the judiciary, excluding the Supreme Court, he's lost. I think that's important because all of us are feeling overwhelmed. All of us are feeling like, does anybody understand what we're seeing, right? Because we're seeing American democracy unravel in front of our very eyes. And we're asking, does anyone see this too? And by all accounts, the courts see it. People say, well, the Supreme Court doesn't see it. Well, the Supreme Court not only sees it, they're deliberately involved in doing it. But the question is, what do the judges see and or think? And the answer is, most of them are not Eileen Cannon. Most of them are the appeals court that shot her down. And most judges take their job very seriously. There are many who, it's just a 9 to 5, you go in, well, 9 to 2, really. But anyways, you go in and you do your job. But a lot of them really take the job seriously and feel like they are participating in keeping the United States of America afloat, and they're not wrong. Earlier this week, on Sunday, a federal judge resigned. His name is Mark L. Wolf. He resigned principally because he felt that judges were not being treated properly. The number of death threats, judges receive death threats and judges are killed on occasion. The number of death threats that is being reported by the Department of Justice has gone up 500% against federal judges. Do you think that's because they're ruling for Trump or against him? 500%. By people who have been told that if they commit violence, like on January 6th, they will be pardoned because it's patriotic to break into Nancy Pelosi's office and defecate on her desk. So this judge believed very strongly that judges should not criticize other judges or the Supreme Court. And you'll find it very hard to find judges who do that. So he resigned so that he could criticize them and defend federal judges who he feels have no defender now that the Supreme Court no longer has their back and is in fact willing to call them out. In 1985, he writes, President Ronald Reagan appointed me as a federal judge. I was 38 years old at the time. I looked forward to serving for the rest of my life. However, I resigned, relinquishing that lifetime appointment and giving up the opportunity for public service that I have loved. My reason is simple. I no longer can bear to be restrained by what judges say publicly or do outside the courtroom. President Donald Trump is using the law for partisan purposes, attacking his adversaries while sparing his friends and donors from investigation, prosecution, and possible punishment. This is contrary to everything that I have stood for in my more than 50 years in the Department of Justice and on the bench. The White House's assault on the rule of law is so deeply disturbing to me that I feel compelled to speak out. Silence for me is now intolerable. There's a Boston judge writing in The Atlantic. When I accepted the nomination to serve as a U.S. District Court judge in Massachusetts, I took pride in becoming a part of the federal judiciary that makes our country's ideal of equal justice under the law a reality. A justice that helps to protect democracy, that has authority and responsibility to hold elected officials to the limits of power delegated to them by the people, that strives to ensure that the rights of minority groups, no matter how they are viewed by others, are not violated. This can serve as a check on corruption to prevent public officials from unlawfully enriching themselves. Becoming a federal judge was an ideal opportunity to extend the noble tradition that I have been educated by experience to treasure. Now let's see. I'm not going to read the entire thing. You can find it in The Atlantic, and it's appears to be available for free in The Atlantic. So if we don't have a link to the free version, I will make sure it gets up there, or somebody will make sure it gets up there. Let's see. He talks about Gerald Ford naming Edward Levi as Attorney General, and this is also what Obama told his attorney generals: protect the rights of American citizens, not the president who appointed you. The Attorney General works for us, not for the president. Pam Bondi would be wise to know that. But then again, if she knew that or believed it, should serve no use to Trump. That's why she's there. Let's see. He talked about it. Okay, let's see. I'm trying to find. After Trump launched his own cryptocurrencies, his Department of Justice disbanded its cryptocurrency enforcement unit. The top 220 buyers of Trump's cryptocurrency were invited to a dinner with Trump. 76 of them had invested more than $1 million. The top spender, Justin's son, who was born in China and is a foreign national, reportedly spent more than $10 million. Sun also reportedly spent $75 million on investments issued by cryptocurrency companies controlled by Trump's family. It is illegal for people who are not U.S. citizens to donate to American political candidates. And the most that anyone can donate directly to one candidate is $3,500. There is, however, no indication that an investigation has occurred. Rather, a few months after Sun started purchasing tokens from the Trump family cryptocurrency, the Securities and Exchange Commission paused its fraud suit against Sun and his companies pending the outcome of settlement negotiations. So he's obviously been paying very close attention to what Trump's been doing and how he's been benefiting and how he's been using the Department of Justice to permit him to violate even the most basic laws we have. Trump's angry attacks on the courts have coincided with an unprecedented number of serious threats against judges. There were nearly 200 from March to late May in 2025 alone. This included credible threats, hundreds of vitriolic phone calls, and anonymous, unsolicited pizza deliveries falsely made in the name of the son of a federal judge who was murdered in the judge's home in 2020 by a disgruntled lawyer. Let's see. Resigned in order to speak out, support litigation, and to work with other individuals and organizations dedicated to protecting the rule of law and American democracy. I also intend to advocate for the judges who cannot speak publicly for themselves. I cannot be confident that I will make a difference. I am reminded, however, of what Senator Robert F. Kennedy said in 1966 about ending apartheid in South Africa. Each time a man stands up for an ideal, or acts to improve the lot of others, or strikes out against injustice, he sends forth tiny ripples of hope. Enough of these ripples will eventually become a tidal wave. And as Nobel laureate Seamus Henry wrote, sometimes the longed-for tidal wave of justice can rise up, and hope and harmony rhyme. I want to do all that I can to make this such a time. That was Mark L. Wolf, who resigned this week from the bench in Massachusetts to better advocate for judges who are feeling abandoned by the U.S. Supreme Court or betrayed by the U.S. Supreme Court and by the executive, who is directly assaulting judges who contradict him or speak out against his, rule against him in his judges who've been ruling against him. I had a list of things that he said. The list was fine. I was going over the list of some pretty terrible things he was saying about judges, including that any judge that disagrees with him should be impeached. That's not terrible, but actual threats. And I was going to read the list, and then I realized the list was from 2020. It's the old list. It doesn't even include the stuff he said. Second, let's see. Announced from the caucus. Jeffries Clark Angular plan to file a discharge petition for a 3-year extension of the ACA tax credits today. Let's see. Would be all right. Thank you, Titan. Yeah. So that's interesting. I don't know. So we talked about this last night when the government agreed to reopen. It was based on that there would be a vote in the Senate to extend the ACA tax credits. That there's no guarantee that the vote's going to pass, and I don't see it passing in the Senate. But if I don't know why they need to do a discharge petition. But let's see what happens. That'll be interesting. Keep an eye on that. Thank you. So So in Massachusetts was this. This is a, and this was a judge in Massachusetts also who decided to take the opportunity to talk about exactly what Mr. Wolf was saying. And he started in a very unusual way by bringing in and copying a copy of a postcard that he received on June 19th that he has on file in his chambers. Trump has pardons and tanks. What do you have? He replied, Dear Mr. Mrs. Anonymous, alone I have nothing but my sense of duty. Together we are the people of the United States, you and me, have our magnificent Constitution. Here's how that works out in a specific case. This begins the American Association of Professors, Universities, Harvard, and a number of other organizations versus Marco Rubio, the Department of State, Kristi Noem, Department of Homeland Security, and President of the United States of America. Curiosity. Oh, yeah. Okay. I'm going to move forward. I think my mic is having issues. Thank you. So, yep. All right. This was a case about do non-citizens have the right to speak, freedom of speech, which has actually already been decided. Yes, they do. The First Amendment covers non-citizens of the United States. So you will see the judge here references, and this is, by the way, how you actually, you cite how and why you reasoned how you reasoned. But in this particular case, Trump, the Secretary of State, and the Department of Homeland Security were trying to argue that protests at Harvard that were against the genocide being committed by Israel, and genocide is the word that the UN has used. It's been declared a genocide. It is absolutely, irrefutably a genocide. They were starving 2.1 million people to death and doing so deliberately. That this genocide was a bad thing. That's what they were arguing. That's all they were arguing. And they were protesting that the United States itself and these universities were abandoning their intellectual and moral obligation to stand up against said genocide. And I don't think that should be a particularly contentious argument. But it was seen as a terrorist threat. It was broken up by ICE, and a number of people were jailed. They were suing for what they claimed was an attempt by Donald J. Trump and his administration to chill free speech on the grounds that all they have to do is break up a few protests, arrest just a few people, and especially deport anybody they can. And anybody who's not in this country is going to be too afraid to speak, and anybody who's in this country is going to be in roughly the same boat. So this case, perhaps the most important ever to fall within this jurisdiction of this district court, squarely presents the issue whether non-citizens lawfully present here in the U.S. actually have the same free speech rights as the rest of us. The court will answer this constitutional question unequivocally. Yes, they do. No law means no law. The First Amendment does not draw President Trump's invidious distinction and is not to be found in our history or jurisprudence. No one's freedom of speech is unlimited, of course, but there are limits to the same for both citizens and non-citizens alike. The First Amendment says that the government will make no law abridging free speech. It doesn't delineate for Americans or non-Americans. This constitutional ruling firmly undergirding its approach, the court here held a full hearing and a 9-day bench trial on the issue of whether the rights of those plaintiffs in the constitutional freedoms of speech have been unconstitutionally chilled by the deliberate conduct of any or all of the public official defendants. The court heard 15 witnesses, admitted 250 exhibits consisting of documents, photographs, and video clips. Having carefully considered the entirety of the record, this court finds by clear and convincing evidence that the Secretary of Homeland Security, Kristi Noem, the Secretary of State, Marco Rubio, together with subordinate officials and agents of each of them, deliberately and with purposeful forethought, did so concert their actions and those of their two departments intentionally to chill the rights and freedoms of speech and peaceably to assemble of the non-citizen plaintiff members of the plaintiff associations. What remains after issuing this opinion is to consider what, if anything, may be done to remedy these constitutional violations. So, excuse me. Finding of fact gets into what everybody has agreed upon are facts and or what are the facts of them. There's a lot to skip. This was a 160-page ruling. By the way, I'd like to point out, in a lot of cases, they don't have a trial for something like this. The judge decided he wanted a trial. He wanted a trial because he wanted a record of what was going on, in a way very similar to Mr. Wolf. He felt that people weren't taking seriously the violations of the Constitution that were becoming regular and the threats, like what he got at the beginning. Donald Trump has tanks. He literally put that into his order just to show what he's getting. Let's see. He talks about how many Palestinians have been killed and injured, why this has created protests in the U.S. He also mentions that one can be, Donald Trump had done 2 executive orders, which he says were deliberately vague enough that he said that anti-Semitism would not be tolerated, but he made it so that anything that was against something that Israel did, say murdering people, would be considered anti-Semitic. Even being pro-saving a Palestinian child could be considered anti-Semitic. Therefore, unless you agreed with everything that the state of Israel ever had done in history, you could be found in violation of his executive order. Let's see. The president declared that it is the policy of the United States to protect its citizens from aliens who commit terrorist attacks, threaten national security, espouse hateful ideology. You'd have to get rid of all of MAGA if you were going to actually follow that law. I mean, give me a break. I've heard MAGA talk. I've heard MAGA talk about liberals. You're gonna deport people or stop hateful ideology? I don't think so. Or people who espouse it. But what does it mean to espouse hateful ideology? In fact, espousing hateful ideology is explicitly protected. He also talks about the second executive order that states that aliens admitted to the United States do not bear hostile attitudes towards its citizens, culture, government, institutions, or founding principles. Again, he said that's not a requirement for entering this country. It never has been, and is once again a violation of the First Amendment. Anybody can espouse contempt for our founding principles. That's one of our founding principles. Let's see. The president issued a fact sheet along with the executive order saying that immediate action would be taken to investigate and punish anti-Jewish racism in leftist and American corporate colleges and universities. So first of all, if anybody says anything anti-Jewish on the right, they're okay. And second of all, what is anti-Jewish racism? Again, is it disagreeing with something Netanyahu says or does? Is it disagreeing with something Mossad does? Is it disagreeing with something the state of Israel does? Where's the line? Secretary Rubio here basically saying those who support designated terrorist organizations, including Hamas, threaten our national security. So this was what was used in this particular case to break up a protest at Harvard, saying that because the people were pro-Palestinians getting food, just opening up the gates to allow Egypt to send food to 2.1 million starving Palestinians, this was supporting Hamas because Hamas was somewhere embedded and hiding in, there'd be like, what, 200 Hamas agents in the 2 million people starving. So by saying you wanted the Palestinians to not starve to death, you were supporting a terrorist group. That was the argument that Marco Rubio was making. Let's see. This is about the order for Mohammed Khalil. They talk about his, and this is again, the courts repeatedly, as they're trying to get rid of him, as he's trying to organize a protest, and they're saying, well, that makes him a terrorist. The courts repeatedly say, it doesn't, you haven't made that. So once again, Trump administration just getting its ass handed to it by the courts. I think what I'm actually going to do is, because we're running a little later than I had intended, and that's just because more breaking. It's been an interesting day. Repeatedly, Rubio gets asked a lot of questions, and he doesn't seem to answer any of them. He goes on about being here as a guest, and as a guest, you have an obligation to speak the way we want you to. And he's like, that's not what we asked. But they ask him about, is Mr. Khalil a terrorist? How do you know? Under what? And he just, it's all circular. Like I said, I think I'm going to skip this. I'm going to head towards the end, which is just basically saying we're going to, if you don't act in a way that we approve of, we're going to take away your visa. That's what he says repeatedly. The inference from factual record. This is public officials witness all deny the existence of an ideological deportation policy. So basically what he's saying here is the judge has found that their deportation policy is ideologically based, and they're all denying it, but it's true. There was no ideological deportation policy. This is, I think, Rubio. It was never the secretary's immediate intention to deport all pro-Palestinian non-citizens for the obvious First Amendment. Yeah, yes, it was. He was going. They were literally sending ICE to all of these things to deport them. Rather, the intent of the secretary was more invidious to to target a few for speaking out and then use the full rigor of Immigration and Nationality Act in ways that had never been used before to have them publicly deported with the goal of tamping down pro-Palestinian protests and terror. So, so the judge makes actually a very good distinction here that I'd forgotten, which was they weren't going to deport all Palestinians or all pro-Palestinians. They just wanted to deport enough that you were terrified of them. Now, terrified of ICE and terrified of the government. I'd like to point out, I'm not very much of a conspiracy theorist. We had a downtime where Lance said this exact same thing. I said, they just want to deport enough that people are scared. And here's a Boston judge putting it on the record That is exactly his finding, having spoken to Rubio and Kristi Noem. The great paradox of this case is that the government's witnesses, to a person, are decent, credible, dedicated, nonpartisan professionals, true patriots who, in order to do their duty, have been weaponized by their highest superiors to reach foregone conclusions for the most ignoble ends. There was no ideological deportation policy. It was never the Secretary's immediate intention to deport all pro-Palestinian non-citizens for that obvious First Amendment violation that could have raised a major outcry. Rather, it was the intention of the Secretaries. The intention of the Secretaries was more invidious: to target a few for speaking out, and then use the full rigor of the Immigration and Nationality Act in ways that it had never been used before, to have them publicly deported with the goal of tamping down pro-Palestinian student protests and terrorizing similarly situated non-citizen and other pro-Palestinians into silence because their views were unwelcome. The secretaries have succeeded, apparently well beyond their immediate intentions. One may speculate that they acted under the instructions from the White House, but the speculation is not evidence, and this court does not so find. What is clear, however, is that the president may not have authorized this operation or even known about it. But once it was in play, the president wholeheartedly supported it, making many individual case-specific comments, some quite cruel, that demonstrated he had been fully briefed. Such conduct, of course, violates his sacred oath to faithfully execute the office of the President of the United States and, to the best of his ability, preserve, protect, and defend the Constitution of the United States. The U.S., by ignoring the Constitution's commands, that the President take care of that the laws be faithfully executed. Sorry, hold on a second. I gotta check. Second. All right, this is a federal judge. This is a federal judge. In the golden age of our democracy, this opinion might end here. After all, the facts prove that the president himself approves truly scandalous and unconstitutional suppression of free speech on the part of his two senior cabinet secretaries. One would imagine that the corrective would follow as a matter of course from the appropriate authorities. Yet nothing will happen. The Department of Justice remains the president, and the Congress is occupied with other weighty matters. Nor will there be any meaningful public outcry. There is an amalgam of reasons. The president in recent months has strikingly, unapologetically increased his attack on First Amendment values, balked here and there by district court orders. The issues presented here commenced last March. Despite meaningless but effective worst of the worst rhetoric, however, ICE has nothing to do with criminal law enforcement and seeks to avoid actual criminal courts at all costs. It is carrying a civil law mandate pressed by our courts and pressed into its furthest reach by the president. Even so, it drapes itself in the public understanding of criminal law through its warrants, none of which are real warrants, by the way, and are unreviewed and, oh, wow, I have to slow down, are but unreviewed orders from an ICE superior, and its immigration courts are not truly courts at all, but hearings before officers who cannot challenge the legal interpretations they are given. Under the unitary president theory, they must speak with his voice. The people's presence as jurors is unthinkable. And there's the issue of masks. The court has listened carefully to the reasoning given by Ortuk's captors for masking up and has heard the same reasons advanced by the defendant Todd Lyons, acting director of ICE. It rejects this testimony as disingenuous, squalid, and dishonorable. ICE goes masked for a single reason: to terrorize Americans into quiescence. Small wonder ICE often seems to need our respected military to guard them as they go about implementing our immigration laws. It should be noted that our troops do not ordinarily wear masks. Can you imagine a masked Marine? It is a matter of honor, and honor still matters. To us, masks are associated with the cowardly desperados and the despised Ku Klux Klan. In all our history, we have never tolerated an armed, masked, secret police. Carrying on in this fashion, ICE brings indelible obliquity to this administration and to everyone who works with it. We cannot escape history, Lincoln rightly said. It will light us down in honor or dishonor to the last generation. See, again, I wanted to read this because I thought that he put very well what we're seeing, and his court's opinion on it, and from what I can tell, the opinion of a number of courts, and the opinion of most courts. Again, I've said it a bunch of times, I'll probably say it at least one more time. 94% have ruled against Trump. The problem is the Supreme Court, who, by the way, can be impeached if the Dems win back the House, but that's for another show. He obviously finds that there was coercion, that there was a violation of the First Amendment. Finds standing. Let's go. I did think that his explanation of what ICE was doing and why it was a problem was very well put, and it was nice to see it codified in law. It'll be in those books that you see behind the lawyers, and he's not the only one. This isn't an outlier, but it was the easiest to find right now, and I think judges are really starting to be fed up with the threats and with the attacks on it by the executive without support from the Supreme Court. There's going to, if this continues, there is going to be a massive fissure in the judicial branch between the U.S. Supreme Court, which is completely out of touch with reality and out of touch with its own constituents, which isn't the United States of America, but it's the lower courts. Let's see. For all these reasons, the court finds as fact and concludes as a matter of law that Noam, Rubio, and their agents misused the sweeping powers of their representative offices. They did so in order to strike fear into individuals, proactively curbing lawful pro-Palestinian speech and the freedom of speech that is their right. Moreover, the effect of these targeted deportations continues unconstitutionally to chill freedom of speech to this day. Now, he talks about why Trump is successful. He seems to be winning. Talks about Trump simply ignores every ruling against him. Let's see. He laments that law firms are starting to cower, and of course they are. The judiciary is not really empowered at this point to protect them, which is his job. This is one of the most stunning. I keep wanting to call it a brief rulings I have ever seen. And then he says, and he keeps bullying on, and he gives examples of Trump threatening and bullying not only the legislative and judicial branches, but also law firms, media outlets. Dissent elsewhere among people is likewise disfavored, often in colorful, surrealist terms. He talks about traitors and treason and the retribution that people get if they disagree with Trump or somehow find against him. So then he asks, what can he do about it? The answer is not much, for the reasons given. Trump has cowed the courts. He's ignoring the rules. The Supreme Court lets him do that now. The Supreme Court has basically said he is above the law. So he finds no order entered by this court shall materially interfere with the defendant public officials and their agents' ability to properly enforce the laws passed by Congress. To this delicate task, this court will turn in the remedy phrase. Freedom is a fragile thing, and it's never more than one generation away from extinction. It's not ours by way of inheritance. It must be fought for and defended constantly by each generation, for it comes only once to a people. I first heard those words of President Ronald Reagan's back in 2007 when my son quoted them in the Labor Day celebration speech at the Norfolk Superior Court. I was deeply moved and hold these words before me as I discharge judicial duties. As I read and reread the record in this case, listened widely, and reflected extensively, I've come to the belief that President Trump truly understands and appreciates the full import of President Reagan's inspiring message. Yet I fear he draws from it a darker, more cynical message. I fear President Trump believes the American people are so divided that today they will not stand up, fight for, and defend our most precious constitutional values so long as they are lulled into thinking their own personal interests are not affected. Is he correct? To the man who threatened him, I hope you found this helpful. Thank you for writing. It shows you care. You should. Sincerely and respectfully, Bill Young. P.S. Next time you're in Boston, the postcard was marked from the Philadelphia area. Stop in at the courthouse and watch your fellow citizens sitting as jurors, reaching out for justice. It is here and in courthouses just like this one, both state and federal, spreading through our land, that the Constitution is most vibrantly alive. For it is well said that, quote, where a jury sits, there burns the lamp of liberty. That to the man who reminded him that Trump has tanks and wanted to know what he's got. All right, I'm going to check in on the live chat. That was a long go of it, but thank you. I think that was important and worth it. So, Jester, $5. God, didn't we just see you? Yeah, I know. And like I said before, in case you missed the beginning, so we did a breaking on the new emails. One strongly seems to imply that, well, no, it doesn't imply. It's Epstein saying that Trump can be blackmailed by what's been going on and what he's been involved in with the whole Epstein thing. So, suggesting maybe blackmail him if he wins and becomes president. So, Epstein clearly thought whatever Trump had done was blackmail president level material. So that email got released, and then another one saying that there was another victim that Trump spent hours with, and the White House was kind enough to explain that that victim was Virginia Guffrey. That was unexpected. I didn't expect the White House to come out and say that. Thank you, White House. Yeah. And we've still got one more show at 9 p.m. Anyways, are you getting enough attention at home? Much love. Keep it at your silly attention. Yeah, I know. I'm that light comes on, and I'm just like, now is my moment. Papa Dutch, $5. The greatest threat to American freedom is a government that ignores the Constitution. Thomas Jefferson. Yep. And Papa Dutch, 14-month follower member. And there goes back to the beginning. Yep. It's 160 pages. So it does go a while. But it's nice to see a federal judge who understands what's going on and cares enough to have done what he did. And again, given the ratio of wins to losses for Trump at the federal level and at the state level, suggests to me that the judges are very much aware of what is going on. You don't get to be a judge unless you've been around the block. Judges are hired from lawyers, so if you've been a practicing lawyer for a while, then you usually get to be a judge if you're any good. So they've been around the block. They've seen how these things really work, and it was inspiring to see a judge who had a pretty good idea of what Trump was doing and was willing to write it down and say, this is what I'm seeing, and what are we going to do about it? And was still so magnanimous in at least one of the threats that we had gotten against him. So, all right, tonight at 9 p.m. Eastern, we will be hosting another In Time. We will be with Dr. Greg discussing long COVID. The mortality rates have not gone down to the pre-COVID levels as they were expected to. There's a lot of talk of fertility issues, cognitive issues, long COVID, so on and so forth. So we're going to discuss where we stand, what we know about long COVID, and how it's affecting all of us. That will be at 9 p.m. Eastern Standard Time. Look forward to seeing you all then. Thank you very much for coming, and have a good evening. See you at 9.